Hi everyone! Thank you for watching this presentation of the research I've been conducting on dress codes in the workplace, more specifically an intersectional analysis of the impact of dress codes on Muslim women in the workplace. Here's an overview of the structure of the presentation today. We'll be starting off broadly by looking at dress codes in the workplace generally and how human rights legislation applies. Next, we'll do a very brief overview of two feminist frameworks that we can use to help analyze dress code issues. Next, we'll look specifically at the application of dress codes in the workplace to Muslim women, including empirical data, some case law, and a mini case study of Bill 21 in Quebec that mandates religious neutrality for some public sector jobs. Finally, I'll leave you with a few reflection questions that you can use for your written commentaries. I want to start off with a temperature check on how we feel about dress codes. So just off the top of your head, do you think that dress codes in the workplace are helpful or harmful? You can think about this from a legal perspective or just a practical perspective, but I've also listed a few different lenses through which you can evaluate dress codes. From a sex or gendered perspective, you can argue that dress codes are harmful because they often have disproportionate impacts on women and may involve sexualizing or objectifying women in a way that men don't often experience. Through a socioeconomic lens, you might say that having a uniform, a type of dress code policy, could be an equalizer in the workplace. When everyone wears the same thing, there's less focus on wealth and status disparities between workers, which could make the workforce more cohesive. However, you can also argue that some dress code policies, like an office with a business professional dress requirement, impose significant financial pressures on employees or create social gaps between employees of different economic backgrounds. From an inclusivity perspective, a dress code may be broad and gender neutral, allowing individuals with varying gender expressions to be in compliance without being forced to adhere to stereotypical conventions of masculine and feminine dressing. However, one could argue that all dress codes inhibit self-expression and don't allow for individuals to express themselves authentically in the workplace. From the perspective of the employer, there may be benefits to dress codes, such as maintaining professionalism amongst workers. However, an employer may run into some legal problems if their dress code policy or its enforcement has discriminatory impacts on certain workers. Having and enforcing dress codes in the workplace has the potential to be very gendered in nature. I'm sure you can easily come up with quite a few examples, including explicit ones like requiring women to wear skirts or dresses, while men are required to wear suits. Some examples are more subtly gendered, such as stipulating how long a skirt needs to be or how wide shoulder straps on a top need to be. Even if these policies don't explicitly state that they apply to women, they seem to be targeted at regulating stereotypically feminine expressions of gender identity. From an intersectional perspective, which I'll elaborate further on in the coming slides, there is also significant potential for dress codes to unfairly target persons of color, people within the LGBTQ+ community, persons with disabilities, and religious minorities. To protect against potential discrimination that may arise from dress code policies, a human rights scheme applies in the sphere of employment to protect workers. The area of the law that applies to dress codes in the workplace is human rights legislation. Federally, the Canadian Human Rights Act extends human rights protections to unionized and non-unionized workers employed by the federal government or by private companies in industries regulated by the government. The provinces also have human rights legislation in place to protect workers. The legislation I'm going to focus on today is the Ontario Human Rights Code. Ontario's Human Rights Code prohibits discrimination based on certain protected grounds in certain protected social areas, which includes employment. Section 5.1 of the Code specifically states that every person has a right to equal treatment with respect to employment without discrimination. Section 23.1 of the Code also has application to prospective employees, indicating that the hiring process is also subject to these protections from discrimination. The Code lists many protected grounds, but the main ones we'll focus on today include race, ancestry, place of origin, ethnic origin, creed, and sex. The Ontario Human Rights Commission has a policy on dress codes, which states that employers can have dress codes, but only if they do not violate the code. This policy on dress codes specifically addresses sexualized and gender-specific dress codes that reinforce stereotypical and sexist notions about how women ought to look. These types of dress codes are common in the restaurant, bar, or service industry. Employers must be able to prove that any sex-based differences in the dress code are legitimately linked to requirements of the job. Some examples in the case law where it was found that sex-based differences in the dress code that applied to women were discriminatory include in Ballantyne and Molly and Me Tavern, a 1982 case from Ontario, where the employer would not hire Miss Ballantyne because she refused to comply with the dress code policy, which required waitresses who were women to be topless. And in the case of Noseworthy in Canton Restaurant, a 2009 case from Newfoundland, where it was found that Miss Noseworthy was discriminated against on the basis of sex because of a dress code policy that required women to wear skirts to work and denied them the ability to wear pants. A dress code may be discriminatory directly or indirectly by its effects. For example, a dress code that says that women must wear skirts but men can wear pants is an example of direct discrimination. A policy that says all employees must wear the company uniform may seem facially neutral, but could have discriminatory impacts on an employee with a physical disability who needs certain adaptive clothing or who cannot wear some of the pieces of the uniform. This is an example of adverse effects discrimination. However, both direct and adverse impact discrimination are dealt with under the same legal test for discrimination. This is a two-step test, but I'm not going to spend a ton of time on this because most people, having taken constitutional law, employment law, or labor law, have seen this framework before, probably numerous times. The first part of the test comes from cases like Elk Valley, Moore, and Bombardier. Elk Valley is just the most recent reiteration of this. In this step, a claimant must establish that prima facie discrimination occurred. In the second part of the test, which comes from the Supreme Court of Canada in Mayoran, the onus shifts to the employer to establish that the treatment or policy that is discriminatory on its face is actually a bona fide occupational requirement. The third substep of this part of the test raises the issue of accommodation to the point of undue hardship by the employer. Undue hardship is only met when all reasonable measures of accommodation have been attempted and exhausted. The undue hardship factors that a court may consider when determining if an employer has met their duty to accommodate include safety, size of the employer's operations, employee morale, cost, and whether a collective agreement is in place. These are just some of the factors, and it's not an exhaustive list. There has been some interesting case law relevant to our discussion today about religious symbols in the context of discrimination and the duty to accommodate, where safety was raised as an undue hardship factor. The most recent case on this is from 2019 when the Quebec Court of Appeal held in Sing and Montreal Gateway terminals that the employer had accommodated its employees to the point of undue hardship, such that no finding of discrimination could be made. Montreal Gateway attempted to accommodate Sikh truck drivers who wore turbans by having the Sikh drivers stay in the trucks at the port and having others load and unload the trucks. If the Sikh drivers got out of the trucks at the port, for safety reasons, they would be required to wear hard hats, which would then conflict with their religious requirements. However, this accommodation soon became unworkable due to increased congestion in the ports and productivity losses. Because the employer accommodated to the point of undue hardship, discrimination was not found. So in conclusion, while dress codes and their enforcement have the potential to be discriminatory in the workplace, there is human rights legislation in place that attempts to combat this. And as we can see, there is case law that shows that employers have a duty to accommodate, but again, that's only to the point of undue hardship. So shifting gears a bit here, I want to next give a brief overview of two important concepts from feminist theory that I think are essential for analyzing the issue of dress codes in the workplace, specifically the case study I want to dive into today about their impacts on Muslim women. The first framework I want to discuss is intersectionality, which I'm sure is a term that many of you have heard before, but I think it's important to take a closer look. This is a term coined by Kimberly Crenshaw, a leading critical race theory scholar and a law professor. Intersectionality describes the idea of interconnected and overlapping systems of discrimination or disadvantage that mutually reinforce barriers to equality. This theory holds that persons at the intersection of multiple identities, often minority groups, may experience discrimination in unique, compounded, and systemic ways that current anti-discrimination efforts may not be equipped to address. The concept of intersectionality actually came from a U.S. case about workplace discrimination against Black women called DeGraff and Reed and General Motors from 1976. GM was sued because of seniority policy that Emma DeGraffenreid and four other Black women argued targeted the Black women. There had been a series of layoffs based on seniority that disproportionately impacted Black women because the company had not hired any Black women prior to 1964. As the most recent workers to be hired, all of the Black women were the first to be let go of based on the layoffs being according to seniority. The court wouldn't allow Emma DeGraffenreid to plead multiple grounds of discrimination. The court held that because the employer had hired Black men, they had not engaged in racial discrimination, and because the employer had hired white women, the employer had not engaged in sex discrimination. The court held that combining a race and sex-based claim would be unworkable, and that to consider Black women as a separate protected class within the law would risk opening Pandora's box. The term intersectionality helps us to understand that the experience of being both Black and being a woman creates a unique set of hardships and disadvantages. The concept of intersectionality also helps us to question whether the rigid and compartmentalized way in which we structure human rights and discrimination claims in Canadian law, based on specific enumerated grounds, is really able to handle intersectional claims of discrimination. But turning back to the case study that is the focus of this presentation, an intersectional feminist lens is necessary to analyze problems and think of solutions related to dress codes in the workplace. Dress codes may have unique discriminatory impacts on persons at the intersection of sex, ethnicity, religion, and race, such as Muslim women, and we have to think about whether the current human rights scheme is equipped to remedy this compounded and intersecting form of discrimination in any meaningful way. The other concept I wanted to quickly introduce is the idea of tension that exists between global feminism and Western feminism. A key piece of scholarship related to this is Chandra Mohanty's Under Western Eyes, Feminist Scholarship and Colonial Discourses. Mohanty argues that Western feminist scholarship has had the tendency to reduce all women from the developing world to a single collective other, failing to recognize the breadth of diversity and nuance within this group. The language used at the time was the third world woman, which is quite antiquated now, but this category included essentially all non-Western women. Mohanty argues that this homogenous approach to non-Western women amounts to an act of colonialism in Western feminist discourse. This discursive construction of the third world woman includes a paternalistic attitude towards these women, the narrative that this entire category of women is oppressed, and creates and maintains a relational power dynamic between the West and the other. The quote on this slide from Mohanty's work really captures this idea. Feminist analyses which perpetuate and sustain the hegemony of the idea of the superiority of the West produce a corresponding set of universal images of the third world woman, images like the veiled woman, the powerful mother, the chaste virgin, the obedient wife, etc. These images exist in universal ahistoric splendor, setting in motion a colonialist discourse which exercises a very specific power in defining, coding, and maintaining existing first-third world connections. Mohanty argues that the effects of this Western feminist discourse is very harmful to the global feminist movement, and instead argues that a global feminism that seeks to understand and appreciate nuance across the category of woman is the way forward for more effective resistance and inclusive activism. I think this framework is especially important to keep in mind as we talk about dress codes and Muslim women in the workplace, when we discuss ideas like the power dynamics between those implementing the policies and those who they apply to, the idea of paternalism, and the way in which a lack of education can play into stereotypes and the essentializing of Muslim women. So now that we have both the legal framework and this feminist theory backdrop in place, I'd like to explore the specific issue of how dress codes in the workplace uniquely impact Muslim women, and then get into the application of Bill 21 in Quebec that has disproportionately impacted Muslim women in public sector positions and beyond. I think it's a good idea to start out with some of the empirical data that exists in the literature about the discrimination that Muslim women have experienced and continue to experience in the workplace context generally, whether or not a dress code policy is in place. Through an intersectional lens, we can identify that Muslim women may be in triple or quadruple jeopardy of experiencing unique forms of discrimination in employment. Muslim women have intersecting social identities that include a number of prevalently oppressed groups. As women, they face sex discrimination. As Muslims, a religious minority in the West, they face religious discrimination. And as members of ethnic minority groups or racialized minority groups, they may also face race-based or ethnicity-based discrimination. In particular, though, Muslim women who wear a headscarf, hijab, or other head covering may be particularly targeted and subject to greater scrutiny in the workplace, as they are visually identifiable as Muslim, compared to Muslim men who may be able to pass such religious identification. Women who wear a hijab or other head coverings are often stereotyped as being inherently oppressed, potentially not intelligent, or capable enough to make an informed and rational decision about their body. This can have detrimental impacts on Muslim women at the hiring stage, when being considered for promotions, or just in how they're treated every day in the workplace by colleagues. Past studies have shown that the chances of being hired were 40% lower among Muslim women when compared to otherwise similar non-Muslim women in the West. Exacerbating these findings are new studies demonstrating that Muslim women who wear a hijab are 40% less likely to be hired when compared to Muslim women who do not wear a hijab. This finding reveals that the hijab, as a visual identifier, has a significant detrimental impact on a Muslim woman's job prospects, likely due to the prejudicial attitudes associated with this observable sign that a woman is Muslim. These studies reveal that with or without dress codes in place, Muslim women already experience intersectional discrimination in employment. With this context in mind, I wanted to look at the case law in Ontario about the impacts of dress codes on Muslim women as an added layer of potential discrimination. To see how dress codes factored into the discrimination that Muslim women may face in the workplace, I conducted some research on the case law that exists in Ontario. There wasn't a ton of case law that was directly on point, but this case of Oddmax Incorporated in Ontario from 2011 was one example I found that directly addressed the issue of the discriminatory impact of a workplace dress code on a Muslim woman. The respondent in this case was a Bengali Canadian Muslim woman who was also legally blind, so from an intersectional perspective, there are a lot of overlapping axes of identity here to acknowledge. The respondent was dismissed before the end of her probationary period and alleged that she faced discrimination throughout her employment and that she was fired for the same discriminatory reasons. At the Human Rights Tribunal of Ontario, the adjudicator found that 1. The enforcement of workplace policies on dress code were discriminatory against the respondent on the basis of her ancestry, ethnic origin, creed, and sex. 2. That the employer failed to accommodate her religious attire. And 3. That some degree of discrimination played a role in her dismissal. However, upon judicial review at the Superior Court, the decision of the Human Rights Tribunal was set aside. In relation to the finding of discrimination based on the dress code policy, the court found that the tribunal decision lacked legal reasoning and key factual findings. To give you some of the relevant facts here, Oddmax did have a written dress code policy that required business attire in the workplace. The respondent was an observant Muslim woman who adhered to the principle of modest dress and behavior and wore hijab to cover her hair. The respondent argued that the employer failed to accommodate her personal choice with respect to the style of the hijab she wore. This was based on one day that instead of wearing a hijab like she had for the entire previous duration of her employment, she wore a different type of head covering, which was described by the employer as a cap. The employer spoke to the respondent on this day due to several elements of her outfit that the employer felt was not appropriate business attire. Despite the opposite finding at the tribunal, the Superior Court held that the dress code did not have an adverse impact on the respondent due to the requirements of her religion. To quote the decision, there was no indication that the respondent was prevented from wearing her hijab at work, but rather that the employer objected to a specific head covering worn on one occasion that was deemed unprofessional. If it was possible for the respondent to wear a traditional hijab at work, then the respondent's religious rights were not affected by the dress code. The Superior Court held that the adjudicator failed to consider whether it was possible for the respondent to comply with the dress code without compromising her religious requirements, as there was nothing about her religion that required her to wear the form of hijab that she wore on that one particular day. The court concluded that if it was possible for her to wear a religiously acceptable form of hijab that was fully consistent with the dress code, as indeed she had done every day for 6 weeks, Her religious rights were not affected. All that was affected was her sense of style, which apparently was in conflict with that of her employer. This case has a pretty specific set of facts that may reduce its precedential value moving forward, but I do think it's an important takeaway that while employers do have to ensure that their dress code and its enforcement does not conflict with an employee's religious requirements, which is a positive precedent, there are clearly limits to this. There still seems to be some constraint on the choice of the employee to wear different types and styles of head coverings, which the court characterized as a clash of style or personal taste between the employee and the employer. I think it'll be interesting to see moving forward how other cases may characterize these types of choices. Are they stylistic choices or religious choices that we should respect in order to protect the self-determination and autonomy of Muslim women in the workplace? Just something to think about. A particularly salient example I looked at in my research was the introduction of Bill 21 in Quebec. I'm sure many of you have heard about this bill because there was considerable backlash when the Quebec legislature introduced this policy of religious neutrality. Many jurisdictions have attempted to implement these policies of religious neutrality in the workplace, which we can characterize as a type of dress code policy. Belgium and France have done this, and now Quebec has too. In Quebec, there's a unique history of ties between the Catholic Church and the state, but in the 1960s there was a rupture with the start of the Quiet Revolution, which has prompted a movement towards secularism and brings us to 2019 when Bill 21 was introduced. This bill sets out certain persons, particularly public servants who exercise state authority, who are prohibited from wearing religious symbols while they perform their employment duties. So instead of a policy of religious accommodation, which the Human Rights Scheme in Canada tells us that we are required to follow, this bill requires public servants to conform and assimilate. This law is clearly in tension with the constitutional protection of freedom of religion, but the bill was invoked with Section 33, the notwithstanding clause, preemptively shielding it from potential judicial scrutiny related to the human rights violations, aka the Quebec government already knew that this new law would stir up some legal challenge. While the goal of the bill is neutrality, the largest impact of this ban on religious symbols is non-Christian religious minorities. In particular, Muslim women have been identified as a group that is disproportionately impacted by Bill 21. LEAF, which is the Women's Legal Education and Action Fund, a feminist legal organization, put out a public statement condemning Bill 21. LEAF pointed out further troubling implications of Bill 21, such as public sector employees being required to perform their functions with their face uncovered, and those receiving public services to also have their faces uncovered. It really is hard to grasp how a bill that specifically requires faces to be uncovered when giving or receiving public services is neutral, when it's clear that this is going to more severely impact religions that may have some requirement for a head covering, like Islam. In their public statement, LEAF adopted an intersectional lens, arguing that the bill disproportionately targets Muslim women and bars their full participation in society. LEAF highlights that niqab-wearing Muslim women will have fewer employment opportunities and will also be denied access to public services that are available to all others in Quebec. Bill 21 will impair Muslim women's ability to secure employment, achieve promotions, complete their studies, and even access childcare. There's also a concern that Bill 21 has amplified Islamophobic rhetoric in Quebec, particularly gendered aspects of Islamophobia, which uniquely affect Muslim women who wear visible indicators of their faith. This quote from LEAF's public statement captures the element of sex discrimination that results from Bill 21, specifically government regulations limiting what choices women can make about their bodies. I think here it's so important to draw upon the work of Chandra Mohanty and question some of the parallels with Western feminism in her work on discursive colonization. Bill 21 is clearly paternalistic, but is arguably even more problematic if it's also being informed by this reductionist, monolithic narrative of non-Western women as oppressed and in need of liberation. Instead of this intended effect of liberating women, this policy of neutrality is having the opposite effect and is isolating, alienating, and excluding Muslim women from the workforce and society. With an intersectional lens, we can also see that when applied to Muslim women who wear visible symbols of their faith, their ability to make choices about their bodies are especially diminished. I think we need to recognize and challenge this disproportionate lack of choice and counter it with greater education and awareness surrounding the role of choice and autonomy in wearing any sort of head covering. I certainly am no expert on this and have no lived experience with it either, but it seems like there's a vast and varied array of reasons why women choose to wear head coverings. The reasons may be religious, cultural, familial, social, or just about empowerment and personal choice. So, to limit the choices of Muslim women without being educated on how important the role of choice is to wearing a head covering is entirely problematic. This is where I think scholars like Mohanty and Crenshaw would say that our legal responses require an intersectional and global feminist lens to appreciate nuance and prevent this disproportionate burden on women at the intersection of multiple marginalized identities. I know some human rights groups like the Canadian Civil Liberties Association and LEAF have been actively involved in challenging Bill 21, so hopefully, with the incorporation of a feminist lens, this can actually mount some meaningful change moving forward. Finally, I want to leave you all with a few questions that you can consider after watching this presentation and may help with your written commentaries. By no means do you have to answer these questions, but I hope that these are some thought-provoking questions that do allow you to reflect on the key themes discussed in the presentation and help you to evaluate and formulate your own opinions on these topics. I wanted to leave you with some of the sources that I consulted during my research and when making this presentation, just if anyone is curious and wants to continue to read up on any of the cases, literature, or videos that I've mentioned. On this slide here is a list of all of the cases that I referred to. This slide here lists out the major secondary sources that I consulted during my research. This includes academic articles, some websites as well. And finally, here is a link to a TED Talk by Kimberly Crenshaw all about intersectionality. So if you wanted to learn a bit more about that feminist lens, I definitely recommend watching this. Thank you so much for listening to and engaging with this presentation. I really hope you learned something new and had a chance to reflect on the ways in which sex, religion, race, ethnicity, and so many other aspects of identity interact with dress codes in the workplace. If anyone does have any questions, please feel free to reach out to me. I've left my email on the slide just in case. But anyway, thank you so much.